The executor is the person or organisation who's responsible for ensuring that the will is followed. If you consider that your will is the record of your wishes, such as what happens with your assets, when your beneficiaries will inherit, or perhaps even who should be the guardian of your minor children, you can imagine that there are a number of different risks that come from not following it properly. Unless an executor is sufficiently skilled or properly advised, there's a real risk that they'll be out of pocket at the end of the process. A common mistake will be to not properly protect assets. If the deceased estate includes real estate, is the property secured? An executor needs to consider who has access to the property. Is the property insured? Is the policy up to date? And have all the terms and conditions been met? If the deceased estate includes a vehicle, who's got the keys? Is it still being driven and is it insured? Who's responsible for costs if there's an accident? If the executor doesn't know the answers to these questions, they might find themselves either devaluing the estate or paying for things themselves. Moving on from the assets, there are also risks associated with beneficiaries. Firstly, is the will written clearly enough that the executor understands who actually inherits? If some people are inheriting because they're part of a class, for example, if you've said to my grandchildren or to my nieces and nephews, then does the executor know how many people actually fall into that class, let alone who they are and where they are? If the executor thinks that you've got 2 grandchildren, but you've actually got 3, that 3rd grandchild might take legal action if the executor goes ahead and only pays the others. There's also the risk of claims. Once an executor obtains formal court authority to administer the estate, also known as a grant of probate, Victorian law provides for a 6-month period in which someone may make a claim. This is sometimes referred to as the testator family maintenance period. Victorian law is quite broad on who can make a claim, and over the years I've seen estranged family members, de factos, friends and next door neighbours all make some sort of request for a greater share of funds. They don't happen on every estate, but mishandling a claim can cost the estate or the executor money. For example, if an executor was to pay out the funds in an estate 4 or 5 months after death and a claim later arose, that executor may end up paying for the legal bill and any settlement amount out of their own pocket.